and welcome back to Good Day Northern Michigan. The investigation into Michigan State football coach Mel Tucker will jump back into the spotlight in just a few weeks. A university hearing is set for the week of October 5th. Tucker is accused of sexually harassing a rape victim, someone he brought into the school to talk with him and his team about sexual harassment.
And what that investigation looks like is a little tricky. It's a Title IX investigation. There have been no criminal charges filed against Tucker. To talk with us more about the investigation, we want to bring in attorney Bernard Alexander, who specializes in these types of cases. Bernard, thank you so much for joining us here on Good Day.
Thank you.
So let's just start with your first reactions kind of out of the gate when this came to light. Was it, about 8-9 days ago here over the weekend? USA Today came out with an article kind of outlining the allegations of harassment against Mel Tucker.
That's correct, and it's pretty salacious conduct. With regard to Title IX claims, the university has an obligation to investigate once there's a credible complaint made, and because he has a contract with the university, the terms of that contract are called into play because there may be a violation of Title IX, and as a consequence, a violation of the contract that he's employed under.
What's the Title IX connection? One thing we heard in Mel Tucker's response in the days that followed last week was that this is, in his viewpoint, not a Title IX case. There were no criminal charges. This didn't happen at the university. This was a personal, private phone call. Take us through the Title IX connection and what that means.
Well, Title IX is basically a requirement that a university make sure that women are treated fairly and not in a discriminatory manner. In this instance, you have a claim of essentially sexual harassment that has been made. The university has a legal obligation, and many would say a moral obligation, to conduct a fair, prompt, and impartial and good faith investigation with regard to any credible complaint. Here we have a credible complaint with regard to potential sexual harassment, and the coach has a contract with the university, and the terms of that contract say that he can't engage in conduct that essentially embarrasses the university under its own subjective determination. And so here the Title IX requires that the university conduct an investigation, and if the investigation were to find that his conduct was inappropriate, then that would be grounds for terminating his contract.
Okay, so what is this process gonna look like, Bernard? I mean, this seems like very tricky waters to navigate for both sides. How can they investigate this issue, get to the truth of the matter while simultaneously being respectful of both parties?
Well, the obligation that the university has, it's not really an option. They must conduct a prompt, thorough, impartial, good faith investigation. They've hired someone to do that, a person who has previous experience in a Title IX department and previous experience addressing these types of matters. That person conducts an investigation, essentially interviews individuals, collects facts, organizes them, determines whether there's any conflict as to that, anything that is said that it is untrue or does not make sense, collects the information without reaching a conclusion. Then at the hearing that you identified during the week of October 5th, a second individual who also has a similar experience will then try and make a determination as to those facts. They will look at the report that has been prepared by the first attorney and then hear evidence from the two individuals, the coach and the complaining individual, and at that point we'll make a determination one way or another as to whether there's substantiation for the Title IX charge being made, and then make a determination ultimately as to whether there's been a violation of the coach's contract.
Wow.
Bernard Alexander with us, the attorney there, to talk to us about the Mel Tucker case. And Bernard, I'm curious, obviously this does not happen in a courtroom. This is a university investigation. This is, as you said, Title IX investigation. What are the ramifications beyond this? Is it just at that point then up to MSU to say, yes or no, this was enough or not enough to dismiss Mel Tucker? And again, we're talking about a case, second question, I guess, follow-up to that is, we're talking about a case of harassment on a phone call, not to dismiss the severity of it, not to say anything in that respect, but this is not a sexual assault or a rape investigation. Just to be clear, this is a conversation over the phone. So maybe address those 2 points if you could.
Well, it is a conversation over the phone, but there's no reason why that could not at least potentially be sexual harassment. So the issue is with regard to consent, and there's agreement that the conduct occurred, and so the real issue is only as to consent. This isn't a criminal matter where something has to be proved beyond a reasonable doubt. It is a civil matter, which means that there just needs to be a determination as to whether it is more likely than not that the conduct occurred. In this instance, it is a he said, she said, and so we don't know the circumstances as to whether there was or was not consent, but you only need one credible witness to be believed for there to be a conclusion reached as to whether the conduct was inappropriate. So here, that is what's occurring. I understand that the coach thinks it's unfair, but as a practical matter, the university is fulfilling its duty to conduct the investigation, and his being accused does not prevent him from. He doesn't have any defense to being investigated. That being said, I would say typically what occurs is there's confidentiality. You'd ask that all the individuals associated not make any public comments, not do anything to expose someone. And the coach does have a presumption of innocence, but that might be lip service in some circumstances. In this instance, she released, I believe, 1,400 documents or so to the press. You'd hope that wouldn't occur, and sometimes that does not look good in terms of the credibility of her claim. But that being the case, she's not an employee of the university, so she does not have an obligation not to comply with the confidentiality. So the university is stuck with the circumstances, as is the coach, and at the end, that's when he gets to determine whether he keeps his contract or not.
Wow, complicated case. Wow, it seems like the more we talk about it, the more layers there seems to be built up around this. So this is going to be a very interesting investigation. We're absolutely going to need to talk with you again as we get closer to the day, Bernard, because I mean wow, a lot of moving parts here. Just thank you so much for joining us with your insight this morning on Good Day. We greatly appreciate it. We're absolutely going to need to get you back to give us more insight into the Mel Tucker case. So thank you, Bernard.
Thank you.